Hello friends, a significant GST development has emerged from the case of Assistant Commissioner Anti-Evasion versus Aerocom Cushions Private Limited. In this matter, the Supreme Court has dismissed the Revenue Department's special petition and declined to interfere with the judgment of the Bombay High Court concerning the taxability of assignment of leasehold rights. Let us understand the issue. Aerocom Cushions Private Limited held leasehold rights in an industrial plot allotted by MIDC. The company subsequently assigned those leasehold rights along with the factory building to another party after obtaining the necessary approval from MIDC. The Revenue Department sought to levy GST on this transaction by treating it as a taxable supply of service. However, the Bombay High Court disagreed. The court drew a clear distinction between a lease or sublease and an assignment of leasehold rights. According to the court, in a lease or sublease, the original holder continues to retain certain rights, but in assignment, the assignor completely transfers and parts with his rights. Once the assignment takes place, those rights stand extinguished in the hands of the assigner. This distinction formed the core of the judgment. The Bombay High Court held that assignment of leasehold rights is essentially a transfer of benefits arising out of immovable property and therefore cannot be treated as a supply of service merely because consideration is received. The court also observed that for a transaction to qualify as a supply under Section 7 of the CGST Act, it must be made in course of furtherance of business. In the facts of the case, the transfer of leasehold rights was viewed as a transaction relating to immovable property and not an activity connected with the taxpayer's regular manufacturing business. Accordingly, the court concluded that GST was not applicable. Another noteworthy aspect is that the Bombay High Court relied upon the earlier decision of the Gujarat High Court in Gujarat Chamber of Commerce and Industry versus Union of India, where a similar view had been taken in the respect of assignment of leasehold rights. The Revenue Department challenged the Bombay High Court decision before the Supreme Court. The Supreme Court has now dismissed the SLP and declined to interfere with the High Court judgment. However, one important caveat remains. The dismissal of an SLP is not the same as a detailed Supreme Court judgment on the issue. Therefore, while the Bombay High Court decision has received significant support, the legal debate may continue, especially since the appeal arising from the Gujarat High Court judgment is still pending before the Supreme Court. Nevertheless, taxpayers now have the benefit of two High Court decisions consistently holding that assignment of leasehold rights represent a transfer of benefits arising from immovable property and falls outside the scope of taxable supply under GST. This is certainly a development that taxpayers and GST professionals should closely watch. Thank you for watching. Stay connected. More GST and taxable updates. Thank you.